Please note, views and opinions expressed in the course of this program do not represent that of WOTV. Therefore, this channel is not liable to any legal action that may result from this program.
Ẹ kú dédé àsìkò yìí, ẹ sì káàbọ̀ sórí ètò ọmọ Oòduà tó ń dé sójú ìwòran yín o láti iléeṣẹ́ ìkànnì WOTV. Òdu ni wá àwa kì í ṣàìmọ̀ fólókó. A tún ti dé o sórí ètò bá a ti ṣe máa ń dé. Tó ètò ọ̀hún ló wá balẹ̀ báyìí bí ọ̀wàrà òjò sójúde yín o. Àwa òmìnira bá wá pèrè fìdí àbẹ́ máa fìdí tí a pèrè mọ́lẹ̀. Kájọ kan lágbá mi ètò tòní nítorí pé ń dá mú afúra wa lórí ètò lónìí ó gbọgbọ́n. Kódà ó gbẹ̀ngbẹ́ ẹ jẹ́ ń pè ní ó gbẹ̀ngbẹ́ nítorí pé kàyéfì ọ̀rọ̀ kàbìtì la máa ń pè ní kàyéfì ọ̀rọ̀. Tó ẹ bá wá pèrè fìdí àbẹ́ máa fìdí tí a pèrè mọ́lẹ̀ ká kọ́ lágbá mi ètò tọ̀hún ká máa bá kinní ọ̀hún bọ̀ bá a ti ṣe máa ń ṣe tá a máa ń kìbọnú ara wọn lẹ́lẹ́yọ̀ ẹ̀yọ̀ bó bá ti wá yá yín bó bá ti yégun ni o ṣe mọ̀ pé o ti yọrẹ́ àwa tá a wà ń bí náà àbá tẹ̀lé wá bí torí pé bàbá débi iṣẹ́ ṣíṣe náà là á ṣe ó ti wá yá ẹja jọ karabodò torí pé àní karabodò tán ká tó ṣe máa wá parọ́ pò tútù mú wá o ó ti yá bó bá ti yá yín ẹja jọ lọ.
Any Nigerian university and indeed any other person the sum of 1 million naira if such student finds any precedent on stay of execution in criminal proceeding where an acquitted person is by such order restrained from enjoying his freedom. It is an illegality that would haunt Nigeria for a long time to come. But then it was granted because Nnamdi Kanu is of the Igbo extraction and must suffer notwithstanding what the provisions of the laws are. On the part of the Supreme Court, Onyendu Nnamdi Kanu did not jump bail, but rather ran away from the treacherous acts of Operation Python Dance to save his life and physical well-being. At page 10 and 11 of the Supreme Court findings and decisions, it was held that the respondent was on bail and therefore in the custody of the law when his home was illegally invaded by heavily armed military officers of the appellant, causing him to flee from his home and country to secure his life. In the face of such an attack, it was reasonable for him to flee to secure his life and physical well-being. That is what any normal and reasonable human being would do in that circumstance to preserve his life and physical well-being. The High Court in Enugu State, in suit number E20/2023, between Nnamdi Kanu versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023 by Justice A.O. Onovo, in the enrolled order of its judgment declared thus, that the practical application of the Terrorism Prevention Act and the executive or administrative action of the respondents, which directly led to the proscription of IPOB and its listing as a terrorist group, said IPOB being comprised of citizens of Nigeria of Igbo and Eastern Nigeria ethnic group, professing the political opinion of self-determination and the consequential arrest, detention, and prosecution of applicant as member/leader of the said IPOB is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right not to be subjected to any disability or restriction on the basis of his ethnicity as enshrined and guaranteed under Section 42 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and his fundamental rights as enshrined under Article 2, 3, 19, and 20 of the African Charter on Human and People's Rights Act. Both the decision of the Supreme Court on the unlawfulness of the revocation of Onyendu's bail and the judgment of the High Court of Enugu State remains valid, subsisting, and not tinkered with. But no person obeys them because it does not favor the federal government of Nigeria. In fact, Section 2871 of this and 3 of the Constitution that makes it compulsory for all persons and authority to obey and give effect to the judgment of the Supreme Court. And the trial court is never entrenched in the Constitution as to benefit Nnamdi Kanu. It is not disputable that Nnamdi Kanu has the constitutional right to agitate for Biafra. Self-determination is recognized and sanctioned under our laws and under normal circumstances. His prosecutions are the violators of the law of the land. If one may ask, On what premise, therefore, is Mazi Nnamdi Kanu detained in the Department of State Security Service? Are Nigerian court's orders and judgment useless, or useless only as they affect Mazi Nnamdi Kanu? Why is it that when the judgment is against the federal government of Nigeria, they will not be obeyed? But if it's in their favor, they quickly rush to obey it. Thank you. At this point, I will hand over to my friend, Honorable Barrister Jude Ugwai. I'm giving you justice. Sorry. Maybe water here. To have full video. Maybe, no, not on air.
I'm going to be reading 14 pages.
Full video, even if it's 10 hours video.
And wrote a strongly worded letter to the then President of Nigeria to retrace his steps and restore IPOB to its former legal status and cease and desist from further arresting or harassing or persecuting members of IPOB. Yet, from the date of issuance of that decision to when the former president left office, nothing was done. Rather, the opposite was done. The persecution, prosecution, arrest, torture, everything became even worse. It is pertinent to mention at this juncture, perhaps as a necessary digression, that had the former president of Nigeria implemented that directive issuing from the African Union, a lot of people who died numbering in the hundreds, some say in the thousands, and in fact, including Mazi Nnamdi Kanu's infamous extraordinary rendition from Kenya in 2021, wouldn't have happened. A lot of lives would have been saved, and the nation would have been more at peace. And we will not have the insecurity that we are grappling with today in the Southeast. And further to the decision of the African Commission on Human and People's Rights, the United Nations, through its special rapporteurs, transmitted a decision in 2020, May, precisely 2020, no, in October 2020, condemning the proscription, IPOB, and the terrorist tag placed on it. The quotations of what they said are contained in our press release, and they are verbose. But the summary of what they are saying is that the action of the federal government was driven by some ethnic considerations against the Igbo, and that the action offended every known canon of international human rights law. Consequently, this organ, which is a very important organ of the United Nations, directed the federal government to do the opposite by deproscribing IPOB. That the action was never taken to get that done, and so here we have it, that for quite some time now, these things have persisted, and here we are with the dramatis personae, this most single factor in this whole saga is Mazi Nnamdi Kanu, who remains in detention to this day under questionable circumstances. At this juncture, I will yield to my colleague to my right, Barrister Emeka Ejiofor, to take you through some of the analysis of what I have said. Thank you. Kanu, Prince Emmanuel Kanu. Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, recall that Mazi Nnamdi Kanu's case was commenced almost over 9 years ago, when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years, and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. 2, it's also to be recalled that after Nnamdi Kanu was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course, much worse happened after. Recall that those things were declared illegal and unlawful, and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against Nnamdi Kanu and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. 3, now having survived the lethal attacks and having survived this many years in enforced exile, and having undergone all these tribulations and travails, and having been renditioned, these actions, this very action of the federal government of renditioning Nnamdi Kanu triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that Nnamdi Kanu was extraordinarily renditioned, and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. 4, it is noteworthy that on 29th June 2021, as indicated before, Nnamdi Kanu was arraigned. Well, you can say produced in court, albeit secretly, through the back door, and presented before Honorable Justice Binta Moritala Nyako, who was aware that Nnamdi Kanu had cancel of record. The prosecution was aware Nnamdi Kanu had cancel of record, not us, his former lawyers. And the DSS was aware of the information of his cancel of record. Everything was on file. Yet, Nnamdi Kanu, or the court, conducted hearing over the head of Nnamdi Kanu and remanded him to DSS custody without notice to his counsel, not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came, but the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any coroner. 6,